Hello, everyone, and welcome to Sandra's Stenography and Shorthand Dictation for voice writers, captioners, shorthand writers, steno writers, and whoever else may want to learn our secret language and our craft. Welcome today. If this is your first time here, please go ahead and subscribe today. My goal is to get to 400 subscribers, and I'm almost there. So, also, my birthday is this month. So, I'm trying to reach that by my birthday, which is at the end of the month on the 30th. So, if you want to help me out today, please go ahead and hit that subscribe button for me. You can also hit the bell for notifications so you can be the first to be notified when I upload a new video. And I am always uploading new videos, new podcasts. And also, you can leave me a comment below any video, any question you have, any concerns you have, anything that in particular that you would like to see me do on this channel. Please just leave me a comment. I get all comments and I answer to all comments. And you can share the videos. Well, I'm going to stop saying that you can share the videos because some of these videos will be private, so they'll be on my website only. But the ones that are on YouTube, you are welcome to share them. Give me one moment. All right. So today I am back with a dictation for you. I'm sitting rather lower than I usually prefer. But regardless, I am bringing you some dictation today, and it is, let's get up here nice and close. It is on the hearing to examine the prosecution of Ignacio Ramos and Jose Compean. Compean is spelled Compean. Sure is. And I thought this was some juicy dictation that I could do for you guys. And I did do this dictation already, but what ended up happening was there was no volume on that video. So I'm making sure that I've got some volume going on today. So this is some juicy dictation, like I said, that I wanted to bring you. And so let's start at the beginning, shall we? So, is there anything in the description? Yes. Let me read the description. Let's start off there. U.S. Congress Senate Committee on Judiciary. Hearing to examine the prosecution of Ignacio Ramos and Jose Compean. Dates held 2007, July 17th, 2007, 110th Congress, first session. We're going to have some witnesses in this thing. Here are the witnesses. Aguilar David V., Chief Office of Border Patrol, U.S. Customs and Border Protection, Department of Homeland Security, Washington, D.C. We'll also have Louis Barker, former Chief Patrol Agent, El Paso Border Patrol Sector, U.S. Customs and Border Protection, Department of Homeland Security, Washington, D.C. We've also got Bonner T.J., President, National Border Patrol Council, Campo, California. Next up is David L. Botsford, Botsford, Appellate Counsel for Mr. Ramos, Austin, Texas. Then we've got Rohrabacher, Honorable Dana Rohrabacher. That Rohrabacher is Rohrabacher. Representative in Congress from the state of California. And last but not least, we're going to have Johnny Sutton. That is Johnny Sutton, United States Attorney, West District of Texas, San Antonio, Texas. We've got some codes that they're also going to be referring to. Let's go over those. When I say US, I mean that's capital U with a period, capital S with a period, code 18USC 6001. So that's going to be US code 18USC 001. We're going to have US code 18 USC, also capitalized with periods, 6003. Next is going to be US code 18 USC 924. And then there's going to be another one that you're going to have to pay particular attention to, and that's going to be US code 18SC 924 bracket, small bracket, C close small bracket. All right, and let's get into why I wanted to dictate this particular substance to you, because I'm nosy when it comes to these things. And so being having a degree, not only an AA degree in stenography, but also having a degree in nosiness, I ran across this and I was just like, I can't hold this to myself. So I was so excited to be able to bring you that first video, but the volume was not there. There was nothing on the video at all. So, and then I made another video on top of that, and now I can't find that video. So here we are, take number 3. All right, but that's okay. I don't mind, because I don't mind bringing you some tea when I find some Steno shorthand voice writing tea. And let me not forget my captioners. So let me see if there's any type of description. I might have blew this up too. No, not that big. But is there a description before we get started, or should I just give y'all the tea? Let me give you these names. There's going to be the Honorable Tom Coburn. That's Coburn, a U.S. Senator from the state of Oklahoma. Then we're going to have the Honorable, H-O-N, period, is how that would look, John A. Cornyn. That is spelled Cornyn, a U.S. Senator from the state of Texas. We also have Honorable Dianne Feinstein, and that's Feinstein, a U.S. Senator from the state of California. We've talked about the witnesses. And let me allow you to experience what I experienced when I was reading this. So let you, instead of telling you what this is about, let me let you discover on your own. Shall we? And I'm assuming you guys are going to be wanting to write this, so I will try to keep it at a nice and even pace so you can mostly work on your listen for the punctuation, listen for the periods, listen for the semicolons, listen for the dashes. All right? And let me see here. You can work on your accuracy. So let's go ahead and get started, shall we? Here we go. Hearing to examine the prosecution of Ignacio Ramos and Ramos Compean, Tuesday, July 17th, 2007. U.S. Senate Committee on the Judiciary, Washington, D.C. The committee met pursuant to notice at 10 a.m. in room SD 226, Dirksen Senate Office Building. Honorable Dianne Feinstein presiding. President, Senators Feinstein, Kyle, that is spelled Kyl, Sessions, Cornyn, and Coburn. Opening statement of Honorable Dianne Feinstein, a U.S. Senator from the state of California. Senator Feinstein, this hearing will come to order. I want to welcome the witnesses. I want to state the ground rules. This is an emotional subject. I would request that everybody keep their composure at all times. This is not a hearing to judge innocence or guilt. It is a hearing to try to ascertain fact. With respect to the jurisdiction of the Senate, there are a few issues involved in this case that are within our jurisdiction. One of them is a certain law called USC 924C. Another is a policy memo of the Department of Justice, which will become clear. And, of course, always limited, negotiation for limited immunity with someone who has trafficked drugs. On October 19th last year, a federal district judge in El Paso sentenced Border Patrol agents Ignacio Ramos to 11 years and 1 day, and Jose Alonso Compean to 12 years in federal prison. The length of these sentences has raised concerns about the discretion of prosecutors in the charging of offenses and the impact of mandatory minimums those charges carry. Today's hearing is to explore the facts, as I said, and better understand what transpired. Some of the facts that we know are not in dispute. A Mexican national named Asalvador Andretti Davila crossed the border illegally into El Paso, driving a van that contained 743 pounds of marijuana. That chart shows that 750 pounds of marijuana assembled by the Border Patrol. When Border Patrol agents started following him, Aldret Davila turned back toward Mexico, but crashed his van and then tried to flee on foot. Aldret Davila was stopped. A scuffle took place. He then broke away. He was then fired upon by agents Compean and Ramos before he finally escaped into Mexico. No written report of the shooting, as required, was made at the time by any of the Border Patrol agents. Later, when an Arizona Border Patrol agent learned of the incident, he reported it to his supervisor and an investigation was opened. A few weeks later, U.S. investigators went to Mexico and offered Aldret Davila immunity from prosecution for his drug smuggling, plus medical care in the United States, if he would return to testify against agents Ramos and Compean. Agents Ramos and Compean were arrested, and prosecutors later amended their indictment 3 times, adding new criminal charges each time for a total of 12 charges. Significantly, one of the charges added a firearms offense under USC 924C, which carried a 10-year mandatory minimum in addition to whatever other penalties the court would decide to use. The defendants were found not guilty of the most serious charge, assault with intent to commit murder, but convicted of all other counts. Agents Ramos and Compean will remain in prison for more than a decade. Their only hope is to win appeal or for the president to grant them a pardon or commute their sentences. Meanwhile, it is reported that Osvaldo Adret Davila has filed a civil lawsuit in the United States and is seeking $5 million in damages based on the shooting. This case has generated strong emotions on both sides. Critics claim that this is a prosecution that shows how the government's priorities are out of whack when it immunized a drug trafficker so that he can testify against the border agents from whom he admittedly fled. Supporters claim that rogue agents must be stopped and that cutting a deal with a wrongdoer who is a key witness is sometimes necessary in these situations. It is true that the bullet left Aldret Davila permanently injured, but it is also true that Aldret Davila was not an innocent who was caught in the wrong place at the wrong time. I asked my staff to give me an idea of what the amount of marijuana looked like, and again, you have it here. I find it hard to believe that someone trusted with $1 million of drugs is simply an amateur drug mule. So I hope this hearing will help us better understand the facts of the case as well as 18 USC 924. We should also look at an Attorney General's policy rule issued in 2003 that states that federal prosecutors must charge and pursue the most serious, readily provable offense or offenses. As I said, while people have argued both sides, I have not heard many people argue that Agents Ramos and Compean deserve the lengths of these sentences. I understand that U.S. Attorney Johnny Sutton has suggested that he was compelled to file charges that carried the 10-year mandatory minimum in order to comply with this DOJ policy I have just read. Specifically, that is the September 2003 rule from then Attorney General Ashcroft that requires the charging and pursuit of these offenses. I think it will be fruitful for us to explore that policy today to see if prosecutorial discretion is being unduly restricted by DOJ policies in an overly rigid reading of the law. When Congress enacted mandatory minimum sentences, we certainly knew that the charges filed would automatically drive the sentence. But Congress never said that the charges themselves must automatically be filed. The power of the prosecutor has long been heralded as one of the most significant powers in our government. In it lies decisions that can have a huge impact, like in this case, where one charge can significantly drive up the sentence by 10 years. I am very concerned about having in place a policy at the department that takes discretion away from the prosecutors and mandates that all cases must be charged to their fullest without any consideration of the facts and circumstances and whether any lenience is warranted. We do not want or expect prosecutors to be robots. Prosecutorial discretion has been a fundamental part of our criminal justice system for centuries. And where there are mandatory minimums, it seems to me that it is even more important for prosecutors to retain discretion to determine what charges make the most sense in such a case. There are also a number of other issues specific to this case which are worth exploring. I hope to find out if the prosecutors considered bringing administrative actions against Agents Ramos and Compean, or asking them to resign instead of filing criminal charges against them and trying to put them in prison. If that was not considered, why wasn't it? I hope to find out why the government struck the deal that it did with Aldrete de Villa. In particular, I hope to find out if the government considered asking Aldrete de Villa to waive his criminal claims against the United States as part of an immunity deal. If not, why not? There are reports that he is now asking the $5 million for his injuries. I would like to learn more about the potential exposure that our federal government faces on that claim. We have also learned that despite his immunity deal, Aldrete de Villa refused to provide any information on his drug source and refused to provide the names of others who talked about putting together a hunting party that would retaliate for the shooting. I would also like to find out why the government entered into an immunity deal in which Aldrete de Villa got to pick and choose which information he provided. I understand the government argues that Aldrete de Villa refused to give information because he was afraid of retaliation. But that risk is true in any number of cases in which a person agrees to cooperate. Normally, when a person is given immunity, he is supposed to cooperate fully. We have also learned that Mr. Aldrete de Villa re-entered the United States on at least 10 other occasions between March and November 2005, and that the documentation provided by the federal government allowed him to cross the border legally at any time without notifying anyone in the government ahead of time. The government admits that Aldred de Villa crossed the border at least one time without any notice and therefore was in the United States unsupervised. I would like to hear more about the policy that allows for this kind of unsupervised passage into our country and why someone who was known to smuggle in drugs would be given such flexibility. I welcome the witnesses and look forward to their testimony here today. And now I would like to recognize the distinguished ranking member of this hearing, the Senator from Texas, Senator Cornyn. Statement of Honorable John Cornyn, a U.S. Senator from the state of Texas. Senator Cornyn. Thank you, Madam Chairman. I know we have Senator Cowell, the ranking member of the subcommittee here. I have an opening statement, but I would be glad to, Senator Cowell. Go ahead, Senator Cornyn. I want to express my gratitude to you, Senator Feinstein, and to Chairman Leahy for scheduling this hearing. We have been hoping that this day would come for a long time, and I'm glad it is here. I know you have taken a serious interest in this case, as have I, and I look forward to hearing the testimony today. The U.S. Senate has just completed 2 rounds of debate on comprehensive immigration reform. I believe the last effort failed in large part because the American people from across the political spectrum simply do not have confidence in the government's commitment to enforce the law, be it at the border, in the interior, or at the workplace. I think the public's interest in this case of Border Patrol Agent Ramos and Border Patrol Agent Compean is systematic of that distrust because the public sees 2 Border Patrol agents serving long prison sentences while an admitted drug dealer goes free. I think this hearing will serve an important purpose because it will air for the American people, for the first time publicly in this venue, the facts of the case so they can hear them and they can make a judgment for themselves about the controversial aspects of the case. We all know that law enforcement officers hold a special place in our criminal justice system. Anyone who can arrest someone and throw them in jail holds enormous power and must be held to account when they act improperly because, of course, no one is above the law. At the same time, it is important to remember that a law enforcement officer should be treated no worse than any other citizen before the bar of justice. In other words, no special breaks, no special burdens by virtue of their status as a law enforcement officer. It is in this light that I have developed some serious concerns about the judgment calls made during the prosecution of this case. I want to find out if the prosecution offered the drug dealer, find out if the prosecution allowed the drug dealer to violate the terms of his immigration agreement without consequences. Did the drug dealer commit perjury without consequence? Did the government feel the need to prosecute these 2 agents as opposed
to disciplinary action to a degree that they were willing to provide the drug dealer unlimited and unescorted parole visas for various 30-day periods to do who knows what, including possibly transporting additional narcotics? Did the government use the threat of severe criminal charges in a vindictive manner? That is, did the government bring that charge only after the agents declined to negotiate a plea agreement? And ultimately, is this the regular practice at the Department of Justice such that they could have been made so that they have made the cases against non-police officers? So, these two agents have now done 6 months in the federal penitentiary. I have never seen a case so compelling for a pardon or commutation. Now, after they were put in and the president did not pardon them, I introduced the bill. I had our lawyers come in and I asked them if Congress could issue a pardon, if we could do a bill that would affect a pardon. They researched the cases and they said there are some cases that indicate actually that you can, and some that indicate you cannot. And since they were already incarcerated, I said, let us go ahead and draft one. We have drafted one. We introduced it. We have at this point precisely 100 co-sponsors. But I think this is a case which calls out for a pardon or for a commutation. But especially, Chairman Feinstein, I would make sure that you get a response from the government as to why, after the drug dealer was focused on in an investigation, before bringing in a second load of narcotics, that fact, which obviously goes to his credibility and his trustworthiness in this case, in which his testimony was the key driver of these two convictions, why that fact was not communicated to the court. Now, the government may say that did not result in a conviction. In fact, they did not indict as a result of that. But I have read the police report with respect to that. But that certainly does trigger an obligation, a duty on their part to report an activity which goes straight to the credibility of the key witness to the government. And I do not think they did that. And the second thing, of course, I think you should question them on strongly is this. Again, their statement has 7 references to states conclusively 7 times that the drug dealer was unarmed. And of course, that is a key element in this case. There is no evidence that he was unarmed. He was not frisked. He was not searched. Nobody was close to him except the 2 agents, Ramos and Compean. The last thing I would say, and I appreciate you letting me go early, Chairman Feinstein. I appreciate your attention to this case, incidentally. This is a very critical case. You know, we built that fence in San Diego, and we had tons of cases just like this. Not exactly like this, but beatings. Times when Border Patrol were robbed. People came across in vehicles. And the separation that we achieved by having a double fence with a road in between eliminated those. And we also had an average of 8 to 10 murders a year right there on the San Diego border. Most of the time, the people being murdered by the gangs that roamed that border were the people coming in illegally. When we put the double fence up, the murders went from an average of 8 to 10 a year to zero. And incidents like this on our part of the border went to zero. And if you look at the border fence that we passed into law, that is mandated to be constructed in Texas. It appeared to me that the fence includes this area where you are now having these drive-throughs like the one which is the subject of the discussion this morning. It is now the law that we build all 854 miles of border fence. I think we need to get on with it. Thank you for allowing me to testify, Chairman Feinstein, and thank you for your great interest in this case. And Mr. Cornyn, I appreciate the hospitality. I apologize for having to leave early, but I wanted to let you know how strongly I feel. Open bracket, the prepared statement of Representative Hunter appears as a submission for the record. Close bracket. Chairman Feinstein. Well, thank you very much for the testimony, for being here. And I will go to Congressman Rohrabacher. Statement of Honorable Dana Rohrabacher, a representative in Congress from the state of California. Representative Rohrabacher. Well, first and foremost, let me thank you, Senator Feinstein. You have my respect and my appreciation for holding this hearing. As we meet today, it should not escape our attention that the two veteran Border Patrol agents that we are speaking about are in their 180th day of solitary confinement. It just tears at your soul to think that these two men, who had 5 years and 10 years of service to the Border Patrol, respectfully, these men who put their lives at risk every day trying to do one of America's toughest law enforcement jobs, these men are now in solitary confinement for an activity that stems from their interdiction of a drug dealer. Both of these men are military veterans. Both have unblemished work records. Officer Ramos, in fact, was nominated to be Border Patrol Agent of the Year. Then, on February 17th, 2005, Officers Ramos and Compean interdicted a drug smuggler who had just penetrated our border with 743 pounds of narcotics. A high-speed chase ensued, followed by a physical altercation. Agent Compean ended up on the ground. The drug dealer ran toward the border, and as he did, he was turning and, according to the officers, had what appeared to be a shiny object in his hand. And yet there is no reason to believe that that object was not a gun. Yet it appears that the word of the drug dealer was taken over the possibility of the fear of these two law enforcement officers that they were being put in great jeopardy. Shots were fired, and in the aftermath, certainly, and we all admit this, the prescribed Border Patrol procedure was not followed. Ramos and Compean did not do their paperwork. Ramos and Compean and their supervisors, not believing the drug dealer had been hit, decided to forego the hours and hours of laborious paperwork that is required after shooting incidents. Now, that was a wrong decision on their part, but it is understandable as well. They did not think anybody had been hit. They just did not want to spend 6 or 7 hours of their time and the FBI's time and everybody else's time to go through these procedures. That procedural violation, that decision, deserved a reprimand. That decision deserved a reprimand only. Prosecutors in this country are given great discretion, and who will be granted immunity and who will be prosecuted is their call. In this case, the United States Attorney's Office decided to give immunity to a professional drug smuggler, except his word that even though he was in possession of $1 million worth of drugs, that he was unarmed, and then throw the book at the Border Patrol agents, turning into a felony what should have been addressed at most by a 5-day suspension for the violation of procedures. It is totally disingenuous for anyone involved in prosecuting Ramos and Compean to suggest that they had no choice. The choice was prosecuting the drug smuggler for his heinous crimes or prosecuting the Border Patrol agents. Going after the agents required turning reality on its head, trying to turn our protectors into bad guys, exaggerating the importance of not spending the hours muddling through a shooting report when they thought no one had been hit. The prosecutors decided to go after the good guys and gave the bad guy immunity. The prosecutors then, let us note, began to vilify the Border Patrol agents in order to justify their decision. Mr. Sutton has, for example, repeatedly referred to the agents as, quote, corrupt, close quote, in broadcast interviews. When challenged about this, he simply defined, quote, corrupt, close quote, in a way that no one else uses the term. Now, we have heard that before from this administration, and it is unacceptable, especially when you consider the impact that that had on the lives of these people, these two Border Patrol agents who have unblemished records on their job. But it was Mr. Sutton who stood by as Congress was lied to with the claim that these two fine Americans of Mexican descent supposedly bragged that they wanted to go out and, quote, shoot Mexicans, close quote, that day. This later was proven to be a bald-faced lie. Now, who is being prosecuted for lying to Congress? That was said directly to members of Congress who were investigating this incident. This lie was in print on numerous occasions. Why did Mr. Sutton let such a vicious lie simply stand? Why didn't he correct the record? then one must consider that Mr. Sutton has continually described the incident as Ramos and Compean shooting an unarmed man in the back and lying about it. Was Mr. Davila an unarmed man? No, he was not just a man. He was a criminal member of a drug cartel, and he was not shot in the back. He was shot in the buttocks, and the entry wound of the bullet was consistent with the agent's testimony, as well as that of the Army surgeons who removed that bullet, that he was not shot in the back. He was turned with his hand extended as if something was in his hand. I wonder what that was. The agents had exactly 1 split second to decide if their lives were in danger. And finally, let us not forget the worst lie of all, the one that was told to the jury when the U.S. Attorney's Office permitted the prosecutor to describe the drug smuggler as a one-time offender trying to earn enough money to pay for medicine for his sick mother. Mr. Sutton may use pejorative words to describe the drug smuggler now, but it was his prosecutors who insisted to the judge that the jury not be permitted to hear the information directly tying the drug dealer to a second cross-border drug shipment. Now, someone is getting railroaded here. The jury was not able to hear that this drug smuggler had been fingered in a second drug shipment, and it was the U.S. Attorney's Office that insisted to the judge that the jury not be permitted to hear that evidence. This committee may want to ask Mr. Sutton about the date of free border crossing pass that was provided by his office, provided to the drug smuggler, and we might want to determine if the date on that pass coincides with the date on the second drug shipment, because those of us on the House side who have been trying to get to the bottom of this cannot get an answer out of Mr. Sutton about this. Mr. Sutton's office has stonewalled our investigation in the House, and that is why, Senator Feinstein, we are so grateful to you for stepping forward today. Mr. Sutton's office has insisted that we obtain a privacy waiver signed by the drug smuggler before they can release the information as to the dates that were on the drug smuggler's pass. I do not know what contempt of Congress is, but that sounds like it to me. This committee may want to ask Mr. Sutton if all the facts remain the same, but instead Mr. Davila turned out to be a terrorist. Let's say instead of all these narcotics, that Mr. Davila was instead smuggling across the border a van that was filled not with marijuana, but let's say Mr. Davila had a van that was filled with a dirty bomb headed for an American city. Ramos and Compean would be sitting with Ramos and Compean. Would they be sitting in federal prison right now for violating a terrorist's civil rights? Or would they be heralded as the true heroes who they are? In summary, the Ramos and Compean case is the worst miscarriage of justice that I have witnessed in the 30 years I have been in Washington. The decision to give immunity to the drug dealer and throw the book at the Border Patrol agents was a prosecutorial travesty. The whole episode stinks to high heaven. Two of America's brave Border Patrol defenders have had their lives and lives of their families, and their families are here with us today, destroyed by what I see as an elitist, arrogant, and overreaching prosecutor who believes that prosecuting the civil rights of illegal alien criminals is worth destroying the lives of our law enforcement officers for minor procedural violations. With that, I appreciate at long last the opportunity to try to do something to help these brave law enforcement officers. As I say, as we speak, Madam Chairman, they are in their 180th day of solitary confinement because this administration that will give Scooter Libby a commutation of his punishment. This administration lets Scooter Libby go, but these two defenders of our borders have to go in solitary confinement. I pleaded with this administration at least go to the judge and ask him to let these fellows go until their appeal is heard, because their lives are in danger. That request was turned down, and I might say very abruptly and arrogantly. And as we now see, Scooter Libby can be set free. Two Border Patrol agents who languish in solitary confinement, whose lives are in danger. Their lives do not count a bit with this administration. And I appreciate that you, Senator Feinstein, care about these people as individuals and are holding this hearing because of that. Thank you very much. Open bracket. The prepared statement of Representative Rohrabacher appears as a submission for the record. Close bracket. Senator Feinstein. Thank you very much, Congressman Rohrabacher. I have no questions. Do other members of the panel have questions of the congressman? If not, then we thank you for coming over to this side. We excuse you, and we will proceed with the next panel. Is it almost an hour? I'm going to read for a few more minutes, and then that's going to be it. Senator Feinstein, I would ask TJ Bonner to come forward, and I will introduce the next panel and aggregate. And then we will go right down the line, if that is agreeable. Mr. Bonner is currently the president of the National Border Patrol Council. This is a union within the American Federation of Government Employees, which represents approximately 11,000 non-supervisory Border Patrol employees. Mr. Bonner has held this position since 1989 and has been a Border Patrol agent in the San Diego, California area since 1978. Deputy Chief Barker retired from the U.S. Border Patrol in July 2006 after more than 28 years of service. At the time of his retirement, he was the National Deputy Chief of the Border Patrol in Washington, D.C., where he had served since May of 2005. Prior to that, he served in a number of key leadership positions in the Border Patrol, including the position of Chief Border Patrol Agent in the Laredo and El Paso, Texas sectors. Before joining the Border Patrol in 1978, he was a police officer and acting detective for 5.5 years with the Jersey City Police Department Narcotics Squad. David Botsford is currently serving as appellate counsel for Mr. Ramos. We asked the defense attorneys at the trial if they wish to come and testify on behalf of their clients. We learned that they are prohibited from doing so by the judge. However, Mr. Botsford has volunteered to testify. He is a member of the State Bar of Texas, where he received Outstanding Criminal Defense Lawyer of the Year in 1993, and he was previously served as the president of the Texas Criminal Defense Lawyers Association. He has been listed as a, quote, super lawyer, close quote, and as one of the 5, quote, go-to, close quote, lawyers in Texas criminal defense practice by the publication Texas Lawyer. He is also listed in, quote, the best lawyers in America, close quote. David Aguilar is not present. Is Mr. Aguilar going to testify? Oh, he is on the third panel, I guess. All right. So we will proceed with these witnesses at this time. Mr. Bonner, you are first up. Welcome. Statement of T.J. Bonner, President, National Border Patrol Council, Campo, California. Mr. Bonner, thank you. Chairman Feinstein, Ranking Member Cornyn, other distinguished members of the committee. The National Border Patrol Council appreciates very much the holding of this hearing to get to the bottom of this matter. This is something that has weighed heavily on the minds of not just law enforcement officers across America, but ordinary citizens who look at the facts of this case and wonder how 2 Border Patrol agents who were simply doing their job, defending themselves against an armed drug smuggler, ended up being prosecuted, convicted, and sentenced to 11 and 12 years in prison. This is a travesty of the highest order. The government claims that it prosecuted these 2 agents because they shot an unarmed man in the back, covered up, destroyed evidence, and filed false reports. All of that hinges on whether that person was, in fact, unarmed. In order to reach the conclusion that Salvador Adret Davila was unarmed, you have to discard the physical evidence. The bullet that entered through his body at an angle. You have to ignore the laws of physics. You have to ignore the sworn testimony of the 2 law enforcement officers and place absolutely complete faith in the word of a career criminal. Make no mistake about it. Salvador Adret Davila was not a simple mule, as the prosecution tried to claim, who was looking to earn $1,000 so that he could care for his sick mother. The cartels are not that stupid. They do not throw the keys to a van with $1 million worth of marijuana to someone whom they do not know and say, quote, just drive around, kid, and you will figure it out. Someone will pick you up and escort you into the safe house, and then we will give you $1,000. They are not that foolish. And anyone in our government and our system of justice who honestly believes that You have to really question their intelligence. And I do not question the intelligence of the folks in that office. They are far smarter than that. He was armed. In my 29 years of experience as a law enforcement officer, having captured loads of narcotics and being familiar with many other loads of narcotics that have been captured, when you are dealing with that quantity, they are inevitably, almost invariably armed. Perhaps not to shoot it out with law enforcement officers, but certainly to protect against being ripped off by the competition. This is a very troubling case, and you will hear the strong prong of the testimony is that they tried to cover this up. There was no cover up here. They were required by policy to orally report the fact that they had discharged their firearms. They did not do that for whatever reason, but that is not a crime. That is an administration violation that merits no more than a 5-day suspension. Another part of their case rests on the fact that Agent Compean picked up his shell casings. One of the things that no one ever did was to test him afterwards to see whether he was suffering from post-traumatic stress disorder. Everyone who testified at trial said that Joe Campion was walking around in a fog, in a haze. He had just been assaulted. He has just seen his life flash before his very eyes because someone pointed a weapon at him. And he was clearly suffering from what used to be called, quote, shell shock, close quote, is now called, quote, post-traumatic stress disorder, close quote. No one tested him for that. He reverted to his training. At the firearms range, we are taught after you fire your weapon, you pick up your shell casings and you throw them into the nearest receptacle. He looked around. There was no near receptacle, so he threw them into the drainage ditch. If he really intended to destroy this evidence, he would have taken it as far away as possible and completely destroyed it. Taken it to a smelter, had it melted down. There was no intent there to destroy or to cover up, and there was no filing of a false report. The Border Patrol firearms policy specifically precludes agents from mentioning the fact of a shooting in a written report. That is done by the investigator. The wrongdoing here was bringing 743 pounds of marijuana into the country. That is a felony. And the person who did that was granted immunity by our federal government. And when he was subsequently implicated in another 753 pounds of marijuana, not only was that fact ignored, but it was suppressed. The government argued that the court should not let the jury hear that evidence. And the jury did not hear that evidence, and it would have a bearing on the outcome. In conclusion, the ramifications of this go far beyond those two agents, far beyond just the Border Patrol, where morale has been decimated, and now we are suffering the effects of that. We cannot hire the number of agents that the president wants, that the Congress wants. We are falling so far behind. One of our recruiters relayed to me that someone came up to him after the standard recruiting pitch and said, "You would have to be crazy to join this outfit. You eat your own. You eat your own," close quote. That is a sad commentary that the public has so little faith in our system of justice. and millions of Americans have petitioned this president for executive clemency, and he ignores that. The effects of this are so far-reaching. I would implore you to use your power to order an investigation. Appoint an independent counsel to look into this. Go in, subpoena, get to the heart of this matter, because the fabric of our system of justice depends on resolving this matter expeditiously. Thank you very much. Open bracket. The prepared statement of Mr. Bonner appears as a submission for the record. Close bracket. Senator Feinstein, thank you, Mr. Bonner, former Deputy Chief Barker, and we going to end that sucker right there. We're going to end that right there. So, what you think about the juice? What you think about this juice that I brought y'all? I got that juice. Yes. So, come on now. What you, oh my Lord. All right. So, we've got, let's just call him the Villa. We got the Villa bringing in marijuana. Then we've got, as he's bringing in marijuana, he trying to bring in marijuana. We've got Ramos Compean that spots him, runs him down. There is a struggle. Then you've got he jumps up, I guess, gets loose, runs back towards the Mexican border. Then you've got them shooting at him, but they say they didn't realize they shot him. All right. So he goes back to Mexico, and so he's over there bleeding and dying. And because they say he was permanently injured. This guy was over there. You'll hear that coming up, that he was over there and he was hurt. And so he could have died, to be honest. So not that I'm taking it by side, I'm just saying he could have died. And because you'll hear later, he was in bad shape. And then he comes, so then the prosecutors get this case. And you'll find out how they ended up getting this case, which is also rather interesting. And then they get this case and they go over and they decide to prosecute. So they go over to Mexico and make a deal with this guy and then brings him back to the United States. Where they do that at? When did they start doing that? So then they make a deal with this guy to testify, and you're going to find out some more about how it's, oh my God, you don't even know the half of it yet, about how his, how their fellow employees got involved in this as well. This thing was a mess. So they go get the guy. They tell him, okay, if you testify against him, blah, 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 you know, what did they say? If you testify against this guy, we will give you 12 passes, free passes to come into the United States unsupervised. You can do whatever you want. That's what we'll do. That's what you need to get your drugs across. And then, if that's not bad enough, during the trial, or sometime, because this is going to come up later, he gets caught with a second shipment. So what did they tell him? You know, we're going to look on the other way while you bring in drugs, and then just happen to bust him one time. You know, come on, man. And then that wasn't even allowed to be brought up in the trial. Now, something ain't right back there. As my mama say, something in the milk ain't clean, baby. And then you're going to hear later, oh my goodness, you're going to hear later Charles Manson comes in, and this thing, and like this man said, this thing is so far reaching, because if I'm a law enforcement officer and I'm there doing my job, you mean to tell me that as I'm in the throes of doing my job, I could go to jail. And I think, to me, and you can tell me in the comments what your opinion is, but I think that this to me sounds like a federal prosecutor and a government gone haywire. Why don't you go somewhere to another country and try to bring in that much narcotics? Do you think that they would just let you go and say, hey, you can keep coming back over here and here's some free passes so you can come in unsupervised? Excuse my expression, but hell to the no. And then they got these guys in solitary confinement. 180th day, the man said that is they are in solitary confinement. And where is the guy that testified that was wrong in the first place for trying to bring the drugs in? He's running around free because he's about to get $5 million in this lawsuit against the United States. Can you believe this crap? You know, and that is what's wrong with our government today. Lord help us. We've got a law for everything. You can't even spit on the sidewalk. And, you know, and I think that I trust me, there has to be rules. And I understand that we live in a civilized nation and that there has to be rules. But I heard of a law recently where if you are even seen touching your phone in the car, you can be pulled over. Now, we already can't, and I understand that because distractions cause accidents. Yes, they do. So my daughter just got her driver's license. I always tell her, don't pay attention to that phone. Pay attention to your driving. Because if you don't, you're going to have an accident. Leave for whatever is going on that phone until you are somewhere parked safely. She just got her license this year. So I understand that there does have to be rules. But good God, touching the phone. Come on, man. I think we're going overboard here with the rules, is all I'm trying to say. I think we're going overboard with all of the laws that are in this country. And I know many of them are good laws and for good reasons, but come on. It's just like pounds you over the head and it drains you. And it makes me wonder where we're going. You know, are we headed? I don't know. I don't even want to dwell on that. I digest. But back to the hearing to examine the prosecution of Ignacio Ramos and Jose Compean. I sure would like to get some thoughts on this juiciness. And we are going to continue this. Yes. Might as well. Because I sure got to get down to, I would like to hear the bottom of this thing. I have a lot of questions myself, as long as along with the senators. I have a lot of concern about how this maybe overzealous prosecutor got to where two Border Patrol agents are locked up in prison with one with respective, I believe, 5. Did it say how many years did they get? I think one got, it says it in the beginning. Let's see if I can find that. One got 11 years. Let's see. First, if you believe in the full testimony of the drug dealer, if you accept the statement as fact throughout the 11 and 12-year sentences are extremely unjust. And what do you think? Unjust? Fair? Should the agents be in jail while the drug dealer runs free? Or should the drug dealer be in the jail and the Border Patrol set free? So, bam. I am so glad to bring you this. Yes, I am. So I want to say before I leave, just writing over here, if you would like to become a sponsor of this channel, please hit the PayPal button on my welcome screen. And you can also support me for 99 cents a month on Anchor FM, and that is Anchor FM Let's Write Steno. All of your donations are truly, 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 truly appreciated and will go towards this channel. Right now, I'm looking to get a microphone, and I'd like a nice one. So if you guys would like to contribute and help with that, let me know. Other than that, that's it. That's all I have for you. Please leave your comments in this comment section and have a great day. And don't forget to give the video a thumbs up. And as always, happy writing.